Hey everybody, Steve Schwinn here. So two important things happened this week with regard to sanctuary jurisdictions. First, the United States Court of Appeals for the Seventh Circuit ruled that the Attorney General can't unilaterally withhold federal funds from sanctuary jurisdictions. Second, President Trump indicated that he's thinking about sanctuary jurisdictions in the next round of coronavirus emergency federal spending that would go to the states. What he's suggesting is that the federal government might withhold all or a portion of those funds unless states and local jurisdictions drop their sanctuary policies. I thought we'd take a look at these. Let's go. Let's start with the Seventh Circuit decision. This case arose when the Attorney General unilaterally imposed conditions on the receipt of certain federal law enforcement grants that went to jurisdictions across the country. What the Attorney General said is that jurisdictions would in the future have to cooperate with federal immigration enforcement in order to receive those grants. Now, obviously what this meant then is for sanctuary jurisdictions, which the whole point of a sanctuary jurisdiction is not to cooperate with federal immigration enforcement, that sanctuary jurisdictions would no longer receive this particular federal law enforcement grant unless they changed their policies and started cooperating with federal immigration enforcement authorities. The Seventh Circuit said the Attorney General doesn't have the authority to do that. What the Seventh Circuit said was Congress, not the executive branch, Congress has the so-called power of the purse. Congress has the power of appropriations and can put conditions on federal spending. The Attorney General, the executive branch, cannot do that unilaterally. So unless there's statutory authority from Congress to put those conditions on the grant, and the Seventh Circuit said there wasn't, unless there's statutory authority to do that, the Attorney General's unilateral imposition of those conditions is invalid. The Seventh Circuit is the fifth federal circuit court to deal with the issue. Four of these, including the Seventh Circuit, ruled the way the Seventh Circuit did and said the Attorney General does not have unilateral authority to impose these conditions. One circuit court, the Second Circuit, went the other way. The Second Circuit read the authority in the Attorney General statute more broadly. It said, looking at this authority more broadly, we say that the Attorney General does have statutory authority to impose these conditions on the receipt of the grant. The Supreme Court is almost surely going to have to work this out. But the point stands that Congress has the appropriations power, the so-called power of the purse, which means that Congress, not the executive branch, has the power to direct federal spending and to put conditions on the receipt of federal funds. The question is, did Congress already do that or not under the existing statutory framework? We'll see what the Supreme Court has to say about that question. Let's take a look next at President Trump's apparent attempt to include sanctuary jurisdictions in the next round of emergency funding for coronavirus from the federal government. What President Trump apparently is suggesting is that Congress condition all or some of the next round of funding on jurisdictions dropping their sanctuary policies. So the question is, can Congress do that? Well, we know that Congress has the appropriations power, the power of the purse, and we know that Congress can put conditions on the receipt of federal funds. But there are a couple of problems if Congress were to try to condition the receipt of these particular federal funds on jurisdictions dropping their sanctuary policies. One is that the courts might view that as unduly coercive upon the sanctuary jurisdictions. In other words, Congress is proposing to bail out these jurisdictions in the next round of funding. The jurisdictions don't really have a choice but to accept that money. And if they accept it, and if it's conditioned on them dropping their sanctuary policies, that effectively means that they have to drop their sanctuary policies. That Congress, the federal government, is directing their policies by requiring them, in effect, to drop their sanctuary policies. That could be a constitutional problem. There may be another problem. The Supreme Court has said that when Congress is conditioning federal spending, the condition has to be related to the underlying program. Well, the program here is to bail out states dealing with the coronavirus crisis. The condition has to do with sanctuary jurisdictions. Do sanctuary jurisdictions have anything to do with state bailout and dealing with the coronavirus crisis? That's the question the courts are going to have to work out. If they're not related, then the condition is invalid, it's unconstitutional. But if they are related, then the condition can be constitutional, and Congress may be able to impose that condition on the receipt of those federal funds. But again, we've got to make sure that Congress isn't, in effect, requiring states to drop their sanctuary jurisdiction policies. I hope this has been helpful. We'll check back in when the courts start to rule on some of these questions and see what the courts have done. In the meantime, please stay safe and well. Thank you.